Jones. I'm the executive director for an organization called the Southern Waste Exchange. We're a small nonprofit up in Tallahassee that assists industry with waste issues. We're kind of my 30-second elevator pitch is I'm a matchmaker. I put waste generators in touch with waste users. And in addition to that, one of the things that we do is put on conferences in the environmental sector. So we do this particular conference that we took over from Mike Eastman when he retired. We do the PFAS Forum. We do the Southeast Recycling Conference. I do a waste conversion technology conference, agricultural plastic recycling conference, and then we do a few more that my wife runs in the cannabis space. So those are interesting conferences as well. Allow me just to make a couple of quick opening comments with regard, first off, if probably more important than anything, is if everybody will put their phone on silence, including me. Proceedings. Everything that you see here is going to be recorded, and I will shoot those recordings out to everybody post-event, probably be about a week before I could do that, as well as a PDF of all the presentations that you will see over the next day and a half. List of participants. If you do not want your name, contact information listed on the list of participants, please let me know and I'll extract your contact info. Bathrooms are straight across from this hallway past the escalators. Certificate of attendance. We offer PEs and PGs and others that need continuing education. We've got a self-certification program in place. There is an extra charge of $25 for that. If you want to take care of it here, you can do so, or you can take care of it back at your office. It's all on site. There's a particular affidavit of attendance we'll need you to complete and just document the hours or sessions that you attend, and then we'll issue the certificates within the next 2 weeks. Receptions and breaks will all be in the exhibit hall. Social media pages, one of the advantages, or in my opinion, one of the most important things is the networking at these events. So if you're here to network, I encourage you to join our social media pages so you can keep up with who's doing what in this sector. Last thing, I always like to throw this comment out there, give you the scam notice, right? So everybody gets emails saying, would you like to buy our list of participants for whatever conference it is? Just be be advised that we don't sell our list. Some of these scammers have gotten pretty sophisticated. They're all overseas, and there's nothing I can do about it or any other conference organizer can do about it. They will actually use conference logos, so be careful. Don't buy anything, and don't sign up for a hotel reservation from anybody that calls you. We don't do that. We direct you to our website and let you deal directly with the hotel.
However, if somebody wants to extend your car warranty,
lastly, real quick, I need to thank our sponsors. If it weren't for the sponsors, any conference wouldn't take place. So our gold sponsor, Republic Services, our silver sponsors, we've got a host of sponsors here. I'm not going to read all of them, just in essence and time so that we can get on to the session. Our media sponsors that help us promote the event, and organizations that are involved in the environmental industry here in Florida. Conference organizers. Real quick tidbit in terms of our next event will take place actually here at this hotel in May. It's the PFAS Forum, May 8th through the 10th. Lastly, as part of the remediation conference, year in and year out, we always select a charity. We've actually raised over $265,000 over the last 13 years for a local charity, and typically it's a charity that is designated for a children's cause. This year's charity is Special Ops Warrior Foundation. Real quickly about them, what they do is they raise money to focus on supporting the kids of special operatives that are killed in action. And so yesterday's golf tournament raised a bunch of money for them, and as part of our continuing operation, we have the Drum a Cheer at this conference, which everybody hopefully knows about. If you don't, real quickly, what we're going to be doing is we're doing a raffle. It's a 50-50 raffle that will take place drawing at 6 o'clock tonight in the exhibit hall. The winner has the option to take half the cash that is raised or this bottle of Pappy, which has a value of about $1,200. So it's your call. If somebody chooses the cash and this is still open, I'm going to auction this off tonight because I know I've got some bourbon lovers in the room that would love this. We'll probably set a minimum bid on it so we make sure we get our money back for it and raise some money for the charity. We'll be selling the raffle tickets at the registration desk, or we'll actually have a table set up in front of the exhibit hall at the, by the reception tonight. So with that, my comments have concluded. I am going to turn us into our opening session. Howard Nelson, who is partner and head of environmental practice for Bilzin Sumberg, is going to be our moderator. We've designed this session to allow for some Q&A. So we've just got 2 presentations, but as back end of this, I've noticed over the last couple of years, there's always the desire for more Q&A for some of these sessions. So we've done that for this opening panel. And so with that, Howard, I'm going to turn it over to you, sir.
Thank you very much. Are you presenting my client?
Yes? Not that I think I've ever needed a microphone to be heard, but thanks. So my name is Howard Nelson. I chair the environmental practice at Miami's Bilzin Sumberg. I have the phenomenal pleasure of sitting at this table or sharing this table with 3 not only excellent speakers, but good friends of mine to talk not only about what's going on with PFAS, where is this going, latest litigation, but also NRICs, non-recorded institutional controls. So Ralph DeMeo will be speaking. Ralph is a partner at Guilday Law in Tallahassee, will be speaking on PFAS. Joe Applegate, who is a senior hydrogeologist at Geosyntec, and Michael Goldstein, who's the principal shareholder. Did you say can't hear? Principal shareholder at Goldstein Environmental Law, will be talking about NRICs. We're going to go for a half hour on each of the presentations. I'm going to ask you guys to hold questions until after the 2 sets of presentations, and then we'll go into, if we're on time, about a half hour of Q&A. So, Ralph, the floor is yours.
Great. Thank you very much, Howard. It is a pleasure to be here with my good friends and colleagues and to see all of you here. And thank you again to the sponsors. If you're tired of hearing about PFAS, well, sorry to tell you, you're going to hear a lot more about it in the next couple years. Actually, we've been in a slowdown period here in Florida because of some legislation that we passed a couple years ago that basically mandated that the state of Florida had to stand down on its enforcement. I'm hopeful that you all know by now what PFAS is. I believe Gene's going to make available the presentation, so I'm going to kind of skip over some of the background materials, but they're in here. And some of you all might have to get some new jokes because they've heard these already, but everybody refers to it as the forever chemical because of how persistent it is, but I call it the everywhere chemical because it's everywhere. I work with a number of clients in the solid waste business. It's in landfills, with airports, it's at airports, with fire departments, it's at fire training facilities, wastewater treatment plants. I mean, I could go on. And I'll explain to you what the status of it is in a moment. You know, there's thousands of compounds, as most of you know. The reason it's so persistent and it's so pervasive is because of the number of places and products that it was used in. This all started, 25, 30 years ago with the Teflon coatings. If you wondered why Teflon was so effective, that's because it had PFAS in it, right? And everybody used it. It was a miracle product, right? Your eggs don't stick to the pan. Much as asbestos 50 years ago was a miracle product, 60 years ago. And that's a fair analogy because I'm going to be talking a little bit more about how we end up resolving this through litigation and settlement. Fire departments are in a quandary because the best management practices for putting out chemical fires, particularly those at airports, is to use a PFAS-containing foam. Just this summer, EPA came out with an alternative, but interestingly enough, the FAA does not require the alternative to be used. And when I asked the FAA representative why not, he said because of liability concerns, because the truth is it's not as effective as the PFAS-containing foam. So a lot of interesting twists and turns. Again, very long list of places where this is found, which is why I call it the everywhere chemical. Now, the other significant development this year was in the EPA finally coming out with a proposed maximum contaminant level for PFAS and a health index. Now, the reason that's so important, and I know most of you are in the remediation business, is because, you know, it's one thing to say, okay, this is a problem, let's go find it, but then when you get to the remediation aspect of it, and I know tomorrow you're going to have a panel on this, and I won't touch upon the remediation side, but then when do you stop? How clean is kind of the term that we use in our field. And we don't know the answer to that yet, okay? We really don't. And that drives every decision, and it drives the cost as well. And I'll talk a little bit about where the EPA is on this. Okay, well, this is just a little kind of cheat sheet on where we are and where we've been. 2019, and my good friend Jorge Caspari and I love to use the term PFACalypse. And we wrote an article for the Bar Journal called PFACalypse Now. And when we wrote that, we didn't realize just how much of a PFACalypse this was going to be. But in 2019, you know, 5 years ago, we kind of heard about this PFAS thing, but it really wasn't driving a lot of major decisions from a regulatory and liability standpoint. Well, now, of course, we know that it's here. And as Jorge likes to say, again, with apologies to Game of Thrones, winter isn't just coming, winter is here now, okay? And we'll talk about why in a minute. There were early indications 5 years ago that these substances were present everywhere, but there were no standards, there was no criteria, there was no guidance. Again, we see it, we know it's there, but what do we do about it? Were the questions that were being asked just 5 years ago, okay? Certainly from a remediation standpoint, we didn't know what the approved technologies would be. Even to this day, and I'm pleased to see there's a lot of presenters and people that have booths set up for the varying technologies that are now more developed. But at this point, we really don't have a kind of an official strategy for how to remediate PFAS. We have a general idea of what it's going to cost, and the other thing I'm sure these guys remember me saying before is there's not enough gold in Fort Knox, and that's not an exaggeration. At the end of the day, if the government pushes the proposal of 4 parts per trillion, I don't know how that's going to get paid for. I really don't. But it's good news for all of you in the remediation business, and I guess for us lawyers too. Again, EPA has been grappling with this, and one of the things that I learned the hard way that they don't teach you in law school, and I've been doing this for 40 years, is that how much politics are intertwined in the regulatory and liability side of anything in the environmental arena. EPA has known about PFAS for 15, 20 years in terms of its impacts in the environment. Again, the Teflon issues went back 30 years, 40 years. But there wasn't a sense of urgency, there wasn't a priority, in part because the scientists, including the Science Advisory Board, couldn't agree on how toxic it is, what are the health impacts, is it a carcinogen, et cetera, et cetera. And frankly, up until the Biden administration, there really wasn't a focused effort to try to develop a standard. During the previous administration, not a whole lot happened. And again, this is because of the politics of what's a priority, what is not, okay? And I'm not making a value judgment on that, it is what it is. But they finally got together when Joe Biden announced his agenda for his election. He had at the top of his list in the environmental area, PFAS, believe it or not. It's the first time that a presidential candidate called out a very specific chemical and said, this is going to be a priority in my administration. And once he took office, he directed the EPA to redouble its efforts to establish a standard, and that's why we now have a proposed standard. There's been huge advancements in the last couple years, 2 or 3 years, which we're going to talk a little bit more about. And frankly, I attended in 2019 the first and only workshop that the DEP had on PFAS. It was in Tallahassee. It was led by the Waste Division Director, Tim Barr. And he acknowledged to the group, I think Joe was there and some of the others of you, he acknowledged to the stakeholders present that the department didn't know where this was heading, but that didn't stop them from promulgating what they called a provisional cleanup target level. They said that their authority for doing that, which I still question, was the emerging contaminant rule that allowed them to set standards, quote unquote, even though they're not enforceable. And again, Tim, to his credit, acknowledged they weren't enforceable, but they had to do something, he said to the group. So for the last 5 years, the de facto criteria was the one that came out as a health advisory by EPA. And what they've basically done this year is cut it almost in half. And so those of you that are in the remediation business, those of you that are in the laboratory business understand 4 parts per trillion is astonishingly low. Now we're into EDB territory, or maybe 1,2-dioxane territory, meaning those are the only other precedents I'm aware of where criteria were set that low. And my good friend Chris Teef, the Tallahassee-based toxicologist, likes to say, if the number ends up being 4, that means the number is effectively 0. Meaning you cannot distinguish between 4 parts per trillion, 3 parts per trillion, or 0. Meaning anywhere that PFAS is found, and as I said, it's going to be found, you're going to have to deal with an unbelievably low criteria with as yet unestablished official, quote unquote, remediation technology. It will be a PFAS-apocalypse. Again, I've been doing this 40 years. I've never seen anything like it in the environmental area, and I believe the worst is yet to come, but we'll talk more about that in a minute as well. Okay, well, again, I won't go through this in detail. EPA came out with their strategic roadmap for dealing with PFAS last year. It's a very comprehensive document. If you are interested in the subject, I urge you to take a look at it because it is significant. Essentially, they came up with some guidance. One of the most significant developments that came out of this document is they have been working closely with Congress to establish PFAS constituents as a hazardous substances under CERCLA. And if you don't understand the significance of that, that will be the advent of, ice age level winter if that in fact gets promulgated. Because as I think many of you know, I know the lawyers in the room understand, CERCLA is the most comprehensive and I would say most onerous of all the environmental laws that are out there. It provides for strict liability, no causation or actual release. Other than showing a release, you don't have to show causation. You just have to show there was a release and contamination exists, and that's a hazardous substance, and it's a listed hazardous substance, not even a characteristic one, so you can't even get yourself tested out of it. If it's present, you're in. It's retroactive. It doesn't matter if you act it legally or not. It comes with attorney's fees and consultants' costs. There's private causes of action. Again, the floodgates absolutely would open if that happened. Now, the good news, if you want to consider it good news, and I'll talk about this more in a minute, is that EPA opened up this proposal for public comment. To date, they've received 120,000 comments, which I think is the most they've ever received on any chemical, and there's more coming. As a result of that, and this is from a variety of stakeholders, I wrote one of those as well on behalf of the airports. And as a result of that, EPA is saying that they're going to stay on track for a January 2024 adoption, but I've heard some noise that might have to be delayed because I can promise you there will be rule challenges, and that's going to delay it even further. I'll talk about the consequences to the state of Florida of that in a minute. There's a lot of other aspects to this, effluent guidelines, MCLs, as I mentioned, PFAS disposal and destruction, MPDES implications, which is important to a lot of people, particularly wastewater treatment plants. Okay, again, it's a risk-based approach, which is good news for us for the most part. That's been the approach that the state of Florida has more or less accepted up till now. The public comment period ended theoretically in March, but they've continued to accept comments, and I think you'll see a lot more coming in. Again, I don't have time to go over all of this, but I wanted you to see the schedule. There's the proposal, again, the health-based criteria, the PFOA and PFAS. Again, there's literally thousands of congeners of this chemical, but they're focusing on a couple because those are the ones that appear to be the most pervasive. I just wanted to throw in something, one area that even in Florida to this day has not yet been fully evaluated is the impacts to stormwater. Groundwater, a little bit easier media to get your arms around, so to speak, to do delineation. With stormwater, because by its very nature, where it travels to, particularly non-point source stormwater impacts, every lake, every river, every stream, every estuary, every ocean and bay gets impacted from runoff. So how that's going to work out is anybody's guess right now. There are a number of BMPs, as I said, that are starting to emerge. The AFFF foam has been the focus. The important takeaway for that is that if you own or operate a commercial airport, meaning an FAA-controlled airport, you are mandated to use this AFFF foam for decades that had high levels of PFAS in it. That's the dilemma facing airports. And as I mentioned, they came out finally, years later, just a few months ago, with an alternative foam. It still has low levels of PFAS in it, number one. And number two, the firefighters I work with have said it's not as effective. And let me tell you a quick anecdote. One of the municipal fire department chiefs that I work with in a medium-sized municipality in South Florida, after I laid all this out for him, said, okay, Ralph, let me ask you this. So, I manage crashes that happen at our airport. It's a busy airport. It's an international airport. So I get a call on the hotline. There's been a crash. Plane's on fire. Passengers are inside. I rush my team to the crash site, and I have to make a decision on the spot. Do I use the AFFF foam that contains PFAS, recognizing that it will get into the ground, into the groundwater, into surface waters, cause who knows what kind of damages and concerns and what kind of health impacts, including to my firefighters? Or do I say, I'm not going to do that, and I let people burn alive? He said, what do you think I'm going to do, right? And that was a very chilling anecdote, but it kind of, in my opinion, captured the dilemma that these airports and other facilities that use this foam face. And he said, I have to use it in my training because the BMPs say you got to train with the same material, and not every material behaves the same way. And most of these airports have not yet converted to the new PFAS foam for all the concerns that I just raised. So it's easy to say, well, just don't use it, but it's actually a harder choice to not use it. Okay. Again, Congress directed FAA to no longer require it in airports, but there really is not a viable alternative. The one that just came out is still being evaluated. The airports I represent are not using it for that reason. They want to know a whole lot more about how it works. There's performance standards. There's a mil spec of PFAS-free alternatives. I gave you the site to it if you're interested. Again, in 2023, Congress tasked the FAA, the EPA, and the Department of Defense to develop a plan for airports to transition. So far, that hasn't happened. Okay, well, let's talk about the state of Florida, okay? Again, the state of Florida, it's important to understand, has not promulgated a standard. There is no, in my opinion as a lawyer, legally enforceable standard for any PFAS constituent. Instead, what they have are these provisional cleanup target levels, which the state themselves would acknowledge there's a of questionable authority, let's just say. They won't acknowledge it publicly, but they will privately. Yeah, we understand, and nobody yet has seen fit to challenge it. Frankly, my clients have thought about it, but we decided we'll work with the department. Instead, we focused on the legislation that I'm going to talk more about in a minute, which puts kind of a temporary timeout on enforcement. But before that timeout was put into place by the 2022 legislature, the DEP issued a bunch of 62-780 letters. Some of you might be familiar with those. Those are letters under 62-780 of the Florida Administrative Code that require the recipient to do investigations, follow a timeline, develop recommendations, and implement remediation if it's required. This went out to a couple dozen facilities, primarily local governments, airports, firefighting. The most famous or infamous one is the Florida State Fire College, which is in Ocala, not too far from here, which, guess what, for decades trained with AFFF PFAS-containing foam. They found it, of course, everywhere, because one of the questions I get asked a lot is, well, should I look for it? And I always say, kind of cryptically, only if you want to find it. Because if you're looking around any of the multiple facilities and operations that I mentioned, you're going to find it, okay? It's just a fact, and especially with the numbers 4, right? Well, just to show you the magnitude of the problem, 2 years ago, the legislature awarded in a special line item in the budget $10 million just to deal with the the Florida State Fire College. $10 million, just for one facility, one isolated, relatively small area, okay? I'm gonna talk about damages in a minute, but that gives you a sense. And by the way, that's when the proposed criteria was twice what it is now. As it says there, 18 cities and airports have received these letters. They're in various stages of assessing the problem. I can tell you, though, this is a matter of public record. Everywhere where they've looked, they have found it, okay? Again, proving the point about it being pervasive. Okay, I'll leave this to the toxicologists and the scientists, but I just wanted you to at least see these numbers. These come from DEP, and it's very interesting, let's just say. Okay, well, I'm particularly pleased. I was part of the work group that helped draft and lobby for this bill in 2022. Essentially, as it says in the margin there, if the EPA has not finalized its standards for PFAS in drinking water, groundwater, and soil by January 1st, 2025, DEP must adopt by rule statewide cleanup target levels. Well, what's particularly fascinating about this bill, and maybe it's happened before, but I'm not aware of it, the legislature told the DEP that they have to come back with their proposal to the legislature for its approval. Have you ever heard of such a thing before, Howard? I've never heard of that happening, or Michael? I don't think so. So it's not that the DEP has to do rulemaking and develop a rule that then goes final, subject to challenges. They have to bring that back to the legislature. I don't know, just being a lawyer, there's some separation of... Pardon me?
We're doing pretty much the same thing with TMDLs.
TMDLs, yes, you're right. So, you know, I have a lot of questions. I'm not saying I don't like the idea, but, you know, separation of powers comes to mind and other things. How can they do that? And the whole concept, not to get into a, you know, lesson on Florida government, but the whole concept of our system of government with the separation of powers is that the agencies have the expertise, and we give them a budget, and they're the ones that are supposed to develop these standards and criteria. So then to say, okay, thank you very much for your good work, now we're going to have a bunch of legislators in Tallahassee and a committee decide if that makes sense or not. And if any of you have been to a committee meeting, I mean, there's certainly not a forum for evaluating as complex issues as what you're going to see with this. So I don't know. Again, there's the politics creeping in again. There was I don't know if it's fair to say there was a sense of mistrust, but let's just say there were a lot of stakeholders that weren't sure they were going to be happy with the state, what it does, okay? But from the standpoint of the potentially responsible parties, this imposed what I referred to earlier as a timeout. The legislation says that the department cannot pursue enforcement. Cannot pursue enforcement. And just this morning, I talked with someone in Tallahassee at DEP because another party that I'm working with got a letter as part of their annual review of their groundwater remediation program, and they have been sampling for PFAS for several years now. And the letter said, well, in keeping with, the recent developments in the law, you no longer are required to continue to sample for PFAS, even though they found it. But we think it's a good idea for you to keep doing that. And, at some point when you get to the PARM program, which some of you are familiar with, you're going to have to establish plume stability anyway, so you might as well keep sampling. So they're asking me, so what am I obligated to do legally, right? Yeah, thank you. Well, I don't know what to tell them. I don't know what to tell them because legally, I guess you don't have to do it, but is it prudent to do so? Absolutely. So there's going to be further legislation. Right now, again, because of the politics, we're not expecting a particularly active legislative session, which will start in January, but it's entirely possible, and we're already talking in our work group about additional legislation. This is the CERCLA legislation that I referred to. I just want to take the last couple minutes to talk about the litigation side of things, okay? I have 3 cases pending in the federal multi-district litigation, which has over 2,000 cases now. South Carolina federal court, just for reasons of judicial convenience, is managing this. There's already been one bellwether case. That's the City of Stuart, Florida case involving public water systems. It's settled. Just to give you, again, a sense of the order of magnitude, the collective settlements were about $14 billion to address the public water systems that have PFAS in them, okay? The next bellwether set is going to be personal injury claims, okay? And I don't know how many zeros you can put on the end of that. Again, let's empty Fort Knox because the plaintiffs' lawyers have been circling the airports and the wastewater treatment plants and the landfills. They're signing up people, and they're just biding their time waiting for there to be some further governmental action. There are, as I said, thousands of these cases pending. Mine involve environmental impacts. Those are not going to be decided probably for another 3 years. What I mean by environmental is non-public water system contamination of groundwater. Of course, as you know, in Florida, when EPA promulgates a maximum contaminant level, that applies to groundwater in Florida too, not just to public water systems. I just wanted to give you a sense of all the various cases that are out there. Interestingly enough, the state of Florida last year kind of joined in and filed their own lawsuit, so the state of Florida is actually involved in this. You can see all the different communities. This is in the materials. I mentioned the City of Stuart. I won't go into it in any more detail. Again, you can see the numbers there, pretty significant. Again, dealing only so far with contaminated drinking water supplies. 3M is the major manufacturer for decades. They're the ones that had to write the biggest check. Again, don't have a lot of time to go into the details. What is an estimate of the cost to assess and remediate plus personal injury claims? It's anybody's guess, but we need governmental help on this one. It's really just almost impossible to imagine what the cost will ultimately be. The other thing I'll mention in conclusion, there's already been a major defendant bankruptcy. This bankruptcy, Kitty Fenwell and National Foam, one of the major suppliers of these manufacturers and suppliers, they've already filed for Chapter 11 protection. Our system allows for that, but it really puts into doubt all of the potential claims that are out there. The other thing I want to mention is insurance. I talked to one of my friends who does environmental insurance. She said that the insurance companies are now putting riders into their environmental insurance policies that don't cover PFAS. Nice, huh? So again, hope you get a flavor for the order of magnitude of the problem. Definitely stay tuned. These are the links to all the key materials and key sources. Thank you.
Thank you very much.
Yep.
We're going to move from a relatively national PFAS focus to something closer to home, the use in Florida of non-recorded institutional controls, or NRICs. And Michael, are you starting off?
I am.
Okay.
Howard, thank you. Can everyone hear me? In the back? Okay, very good. Gene, thank you for again allowing me to speak at the conference, and my colleague, Joe Applegate. We're thrilled to be here. It's interesting, anomalous, and appropriate that we're talking about NRICs at the start of the conference. NRICs, non-recorded institutional controls, are a function or an opportunity in the context of conditional closure, which makes our positioning here right out of the gate interesting and anomalous. Interesting because one would think that at a technical conference we would start to talk about closure only after we've talked about all of the technical innovations in remediation, and in that sense because we're coming at the beginning of the process, if you speak, the iterative process of site rehabilitation, at least in the framework of this conference, as opposed to the end. That's a little anomalous, but it's also appropriate. And it's appropriate because if you take a step back, NRICs, which we'll get into in a second, non-recorded institutional controls, are really the mirror image of the proposition and the problem presented by PFAS. As Ralph stated, and stated eloquently, and it's a beautiful way to think about PFAS, PFAS is for sure a forever chemical, but it really is an everywhere problem for the reasons that Ralph stated. And so for an everywhere problem, you need an everywhere solution. And that's what I want us all to start thinking about in terms of NRICs. NRICs are not that well understood yet in a regulatory context amongst practitioners, at least amongst contractors and scientists and consultants. We've been dealing with this opportunity in the brownfields world for a significant period of time, relatively speaking, for the past 24 months. It's more of a legal obsession, if you will, about how to properly bring this opportunity forward and make it more accepted uniformly throughout the state, throughout the various districts, and at the various county program levels. So with all of that being said, the first thing we want to do is you want to bring the slide up, Joe?
Sure.
I want to take some time and go through our abstract carefully to frame the opportunity here precisely, because as we are able to get more certainty at the regulatory level, at the legislative level, I think what is now operating mainly in the shadows in 62-780 context will emerge and really begin to punch above its weight. So having said that, non-recorded controls are institutional controls gaining popularity in Florida for restricting groundwater use, not soil use, groundwater use on impaired properties as part of the process for obtaining conditional closures without the need to record institutional controls on the property deed. This is more than just a regulatory feature. It is almost a transactional, existential feature. I think we're going to get into that in the back and forth in the questions and comments after our presentation. Multiple NRIC types can be utilized, and some of the more common ones currently available in our state include local, municipal, mandatory drinking water hookup requirements, and FDEP delineated rule that includes areas defined as already impacted and restricted for drinking water use. Perhaps the most common and easily applied NRIC in Florida is the use of GIS shapefiles that are provided to and subsequently tracked by the various water management districts. These NRICs have the ability to use GIS shapefiles that delineate groundwater plumes, which once entered into the record, provide a high level of certainty to DEP and local pollution control programs in cases where the NRICs require notification to DEP and the water management districts when water well permits are applied for within the GIS shapefile areas. This presentation will provide a summary of potential NRICs that can be applied in Florida, an update on the use of NRICs in relation to the DEP IC procedure guidance, geographic areas in Florida where GIS shapefiles can be used, and examples critically of NRICs that have been applied for and approved by the FDEP. The amount of case studies in the state of Florida is not that significant, but they're growing, and it's important that we all know where they've been used and applied for and approved before. And then finally, next slide, Joe, before we get into the agenda, I want to try and define the value proposition from a brownfields context, because I think that's where we will see the greatest use of NRICs. More and more of our cleanups that we are seeing, that my colleagues who deal with environmental redevelopment opportunities, and more and more of our cleanups, and generally more and more of our redevelopment projects that require cleanup, involve significant off-site plume components with multiple public rights-of-way and multiple third-party property owners. And many times those multiple rights-of-way, public rights-of-way, are controlled by multiple jurisdictions, the FDEP, county entities, and municipal entities. When a single property owner among many can refuse to execute a DRC, or a single lender can refuse to execute a consent enjoinder, and in so doing completely block a conditional closure that is otherwise ready to be issued, NRICs are increasingly becoming not just the go-to strategy, but the only strategy available to effectuate conditional closure. That's the largest takeaway from an environmental redevelopment context that we see. This is almost existential. It provides really an only way out, an end path to closure. So having said that, I'm going to turn the presentation over to Joe now, who's going to go through with more specificity the various types of NRICs that exist, provide some examples, some case studies. We're going to go through the IC registry data, and then dive deeper into examples of approved NRICs. Joe?
Very good. My name's Joe Applegate. I've had the pleasure of working with these esteemed leading attorneys in Florida for the past 20 years. Ralph and I helped get a closure on the MGP site in Tallahassee, 2019. That was an EPA CERCLA, no further action. Major closure, so we've been working on that for probably 20 years, right, Ralph? At least. First met Michael at the National Brownfield Association meeting in St. Louis. He was then the president of the Florida Brownfield Association, and had the pleasure of working with him on several large brownfield projects. Michael mentioned how difficult it is to get to closure. I've been tracking conditional closures for the last 10 years, and anybody have an idea how many conditionally closed sites there are on the IC registry? This past year, it just exceeded 2,000. And there's about, I've got some statistic slides, there's probably about 35,000 closed sites in Florida. So 2,000 of those are conditionally closed. So we have another acronym, NRICs. I only started hearing this about a year ago, but the Florida Brownfield Association has really advanced the ball on the getting regulatory acceptance for NRICs, and there are many types that we're going to talk about as well. I'm going to give a summary of Florida site closures and some data from the IC registry. And we've got about 6 examples, applications of approved NRICs in Florida that we're going to quickly go over. Michael did a pretty good job in defining an NRIC. Basically, it's any type of conditional closure that's not a deed restriction. And 10 years ago, the majority of conditional closures were deed restriction, declaration of restrictive covenants. The updated Contaminated Cleanup Rule 780 in 2017 kind of established the regulatory framework for approving non-recorded institutional control. So it kind of gave some backbone to people in proposing and getting the regulatory community comfortable with controls that aren't recorded, that they're going to hold up for future activities that might occur on a conditionally closed site. The nice thing about an NRIC is you don't have to go through the DRC process. And everybody that's been through that process, it's a several-year process, to be honest with you. I think I did one in 1 year a long time ago, but it's usually about a 2-year process. So, multiple layers. We'll go through different types, but typically they're layered to give more assurance to regulatory agencies that these will stand up for future land uses. So let's talk about types and examples. Michael mentioned GIS shapefiles. That's probably the most common one. And these are typically just used for off-site contaminant plumes. All that's required from the source property RP is noticing to the off-site. The off-site property owners have the opportunity to challenge it, and they often do. But at the end of the day, if you work things out with the off-site property owner, they don't get a restriction on their property use. So another more common one that's becoming more and more acceptable are local ordinances. These are municipal or local mandatory drinking water hookups. So most municipalities require you to use their drinking water, and you're not allowed to put in your own drinking water well in most cities and municipalities. So those are becoming more and more acceptable from the regulatory agencies. Go back to the first one. The only 3 main areas in Florida where you can do GIS shapefiles right now is Southwest Water Management District has been accepting them for quite a while, and the majority of the case studies for shapefiles is in that district. St. John's Northeast District just came online less than a year ago, so they've had a couple approved in the Northeast, and Palm Beach County has a pretty good GIS system, so there are some GIS approved in that area as well. The third one's not used so much. The delineated areas, that was started years ago for EDB, where large portions of Central Florida were contaminated with EDB, and big circles around big areas were drawn. And they are restricted. If you try to put a well in those areas, it'll flag with the Water Management District. But that's another potential IC. One that's really gaining a lot of closures is the PRP LSSI, no further action. And I've got a case study to talk about that. But 10 years ago, there were very few. Now there's, I think, over 200 LSSI, no further actions. There are DOT, CSX, and Port of MOUs. There's quite a few listed in the IC registry. There are many federal land use LUCIPs, land use control implementation plans at federal facilities. I think there's over 300 or 400 of those. Those are also non-recorded. And then the last part, when you're layering, these are common ones that you might use, including irrigation screening, alternate cleanup target levels, Florida building and plumbing codes, future stormwater systems. That's one of the major concerns DEP has, is if you've got a conditionally closed site and there's some future redevelopment with stormwater systems that could affect plumes. So in the IC registry, there are a lot of references to stormwater restrictions and dewatering restrictions. So those are the majority of the types. This is just an example of the delineated areas. This is petroleum products down in Pembroke Pines. It's got a big circle. Those delineated areas also had a pretty big buffer around the main contamination. So the delineated areas are pretty conservative from a contamination standpoint. So what are the challenges? The challenges are if you try to use zoning, that may not be permanent. Regulators typically don't like to use zoning for NRICs. Local ordinances can be changed or revised down the road, so you have to have some certainty that those restrictions are going to be in play for a long, long time. Permits are only bind the permittee for the life of the permit. Water management restrictions are useful if used in conjunction with other ICs. And comprehensive land use planning can also be changed, revised by local government. So, they do have some challenges as well. Many of these government controls and NRICs only require the sites go on the IC registry, but no deed restrictions required. One other thing I want to add, in 2013, Jorge issued a memorandum that I think helped start the regulatory acceptance of NRICs in allowing, and that was ahead of its time because the 780 wasn't updated till 2017. But basically it opened the door for people to start proposing using non-recorded institutional controls. So regulators like to see as many of these stacked on top of each other to provide a level of assurance that these ICs are going to pass muster for the long term. And they can take a long time. So at the end of the day, you need to evaluate whether it's really worth pursuing regulatory acceptance. Kind of depends where you're at, which regulators you're working with. But at the end of the day, it may be easier just to do a declaration of restrictive covenant than try to do an NRIC. And most of the applications, as we said earlier, are for off-site plumes. Most RPs actually want to have the restriction on their property if they have contamination in place. This is a fun slide. So DEP tracks how many contaminated sites there are in Florida, how many have been cleaned up, how many are awaiting cleanup. And this was, Brian Doherty gave this to me in 2015. If you look at the bottom, there's a total of 35,000 sites in the universe of Florida to clean up. And then there's a column for cleaned up. So there were 35,000 in 2015. About half of them have been cleaned up. And there were about 15,000 awaiting cleanup. And that's petroleum dry cleaning, Superfund, state-owned lands, RP-led sites with the districts, about 8,000 of those, RECRA sites, NPL enforcement, Superfund. These numbers don't change a whole lot. But it's interesting, so about half sites were cleaned up and there were only 35. Fast forward, I just got this from Leah Smith last month. That number went from 35,000 to 50,000. And I don't think this includes all the PFAS sites, so I'm not sure. If you look at this, the petroleum sites haven't changed a lot, maybe another 2,000. Dry cleaning's the same. This number went way up. The responsible party sites went up by like 10,000 sites. So I'm not sure if those are all enforcement sites or exactly what that is. But also interesting is the number of sites that have been cleaned up. We went from 17,000 to 36,000. That's almost 20,000 sites in 8 years. I'm pretty impressed with that. And awaiting cleanup, we only have a lot of these sites are in active cleanup. I think there's only like 15,000. So I think there's been a lot of good progress made in site closures. you may think this is really boring, but I get a kick going through the IC registry and trying to figure out how sites were closed. Back in 2015, there were 1,400 sites closed, and over 1,000, close to 1,100 were DRCs. 2017, you can see the LSSI NFAs doubled in just 2 years. Fast forward to now, over 200 LSSI NFAs. I think the EP has reorganized the IC registry pretty significantly because there's a lot of new categories in here. Some to note, these are federal MOAs, MOUs, DOD, LUCIPs, 23 municipal county ordinances. So you can see there's a lot of different types of conditional closures now, but close to about 40 of those were NRICs that were basically local ordinances and other type restrictions that I went over earlier. So NRICs are gaining regulatory acceptance. We're going to go through, quickly go through about 6 examples, starting back in 2013 after that initial memo came out. And we've got 2 recent ones that we're going to talk about as well. To my knowledge, this is like the first one. It's a muffler shop in Tallahassee. And basically they went through a site assessment, remedial action, testing, LTNAM, slightly exceeded GCTLs in 1 monitoring well, and a conditional closure was approved using a Leon County mandatory hookup. So that's the first one that I'm aware of, 2013. This was 2014. This was actually a Geosyntec dry cleaning site in Orlando. It was then a dental office, formerly a dry cleaner. Went through the assessment and did a remedial action plan, did soil vapor extraction for 3 years, and then went into NAM. The soil remedy was complete. We had 1 well that had PCE slight exceedance on the dissolved plume, but was stable. We contacted the property owner if they were interested in a conditional site closure. They said yes. We used the Chapter 37 article, Orange County, which was basically a mandatory hookup as well. So this is one of the first on-site NRIC that was approved using a local ordinance. That was 2014. This is a real recent one, pretty impressive closure that Michael's going to talk a little bit about, Alliance down in Broward County.
Joe, thank you. Hello? All right, very good. Joe, go to the next slide. That's where I want to start. And can you take the pointer and outline the irregular plume contour? So you can see that this site was complicated. Going back in time, the original site, M1, the source property, which was ultimately closed out with a DRC, a recorded covenant where the client, the property owner, obviously had control of title, and we were able to jump through all the hoops to get the covenant recorded. The property owner was obviously a willing party, and we were able to get the lender on board. Lenders are always required to execute consent enjoinders. That original property decades ago was operated as a janitorial and industrial aerosol cleaning supply company. And they stored a lot of their product in concrete vaults, underground concrete vaults, where someone forgot to put in a bottom, a finished bottom. And so you had this beautiful irregular plume, very artistic, that migrated off-site, northeast and southwest, and impacted 12 other off-site properties. This turned into a wonderful annuity for the environmental contractors and consultants because the approach historically had been pump and treat. And the property owner spent millions and millions of dollars over the years to operate this recovery system. Fast forward to several years ago, and the property owner was in absolute despair. Needed to exit the property. It was the height of the real estate market. They approached our group along with Geosyntec, who also worked on it with us. First thing we did is we put the site in the Florida Brownfields program. That's another conference. There are lots of good reasons to put impacted sites into the Brownfields program. And then we looked for an early exit door. We wanted to get out of the property in order to transact, get out of the remedial loop in order to transact the property. We found ourselves in a very hot real estate market with a number of buyers for the site who loved the property, didn't love the environmental situation, but we had an option. We thought we could thread the needle with a non-recorded institutional control. That's ultimately what happened here. And really, it was the only way, the only solution available to us to get to closure, because we had 12 sophisticated off-site property owners, including 2 public rights-of-way controlled by 2 different jurisdictions, and we didn't feel comfortable that we would be able to get everyone and their lenders to sign off on recorded covenants. This is a little bit like horseshoes and hand grenades. Actually, it's unlike horseshoes and hand grenades. You have to be very precise. You have to run the table. And if you need 10, 12, 15, 1, 2, 40, however many covenants signed, and you lack a single covenant, then conditional closure will not be available to you. You have to keep on doing what you're otherwise doing and take advantage of one of the other RMO options or complete active remediation. And so here we were able to convince Broward County for the first time that and go back to the previous slide, I'm not going to read them all, but the basket of municipal ordinances and county ordinances and even industry building codes that existed were sufficient to provide the same level of protection for human health and the environment that a recorded covenant would, and that unconditional closure would. And that demonstration was sufficient. The county signed off on the proposal. We started sending out notices. This is an interesting issue. It's important for practitioners to understand that the NRIC concept doesn't operate in a vacuum. It's not only considered and interpreted by the amen choir of the property owner proposing the NRIC and the regulator considering the NRIC. Like covenants, every impacted property owner needs to receive notice, but unlike covenants, specifically unlike covenants, impacted property owners do not need to consent, and neither do their lenders. Now, they may have issues, they may have concerns, and indeed we were contacted by a number of impacted property owners, but with through collaboration with the regulatory agency and with Geosyntec, we were able to talk all of the concerned stakeholders and impacted property owners off the ledge, and we did get our site rehabilitation completion order. Prior to issuance of the SRCO, this site was transacted because we were on the we could see the runway in front of us. We were able to demonstrate to the buyer that we were going to get conditional closure, and that buyer closed, and then the property subsequently transacted to a second buyer. That's how hot the real estate market was before closure formally issued. So a great success story.
Excellent. That's amazing. You were able to get closure on 13 offsite properties through NRICs. Quite an accomplishment. Thank you, Michael. I just want to spend a minute or two on the PRP, LSSI, NFAs. since there are so many of these being approved. The conditions you need to have to get an LSSI NFA approved is it's got to be an eligible low-scored site, less than 29. Responsible parties can designate the ATC. The most important thing is your soil concentrations have to be less than the criteria of 50 ppm for diesel or 500 ppm by OVA. It's not lab results, it's the OVA results in the soil. But you can leave contaminated groundwater on site. Has to be demonstrated stable shrinking. Groundwater plume has to be on site, cannot be off site, and you cannot be affecting any surface water. So this is one of my favorite sites to present. I worked on this back in 2016-17. It's an industrial site in the Brownfields corridor in Tallahassee, and it was basically a pretty straightforward UST removal. And you can see, oops, sorry. This is where the UST was. This was in the, oh, time for question? Okay. Anyway, we did an excavation, did 4/4 of PARM, and we got a conditional closure. But while we were on site, and we found a World War II bomb site. And anybody in Tallahassee remember the bomb site? Yeah. Eglin showed up at 4 o'clock with their bomb squad, and at 8:30 they detonated on site. And I hope this video is gonna, no, it's not gonna work. Oh well. Anyway, it was pretty exciting. But after 4/4 of PARM, we did get the LSSI NFA for this site, so that was pretty exciting. Here's another one. This was a site down in Sarasota, 1,4-dioxane plume, had a pump and treat system for 15 years. We went back in with tree wells and basically installed about 154 tree wells located here and here, did a lot of groundwater modeling. Trees can drink about 5 or 10 gallons per day per tree. So if you have hundreds of trees, you can pump a lot of groundwater naturally, and it's treated in the tree roots and expired. So anyway, we did that, and basically dioxane concentrations plummeted after we put the trees in, and we used a layered approach. We used the alternate irrigation cleanup target levels, a DOT MOU, and several other layers. We did do a DRC on the site proper, but for the offsite portion, we did offsite and got a approval from DEP. This one is a real recent one, just got approved last month. It was arsenic pesticides in soil on-site, groundwater off-site. We did a SAR wrap, excavation, engineering controls. The DRC was actually approved by DEP last year, but during the noticing for off-site, we got challenged and had to go through technical evaluations and give the off-site property owner comfort that this plume, this was the source property. There's a 1 acre plume on here, but they were building a large stormwater system. So they wanted to make sure that this plume wasn't going to impact their stormwater. So we had to do quite a bit of modeling and justification, but they've now approved that as well. So. In summary, NRICs are gaining in popularity, as Michael indicated. There's more and more uses of these, mainly for offsite, but some on-site. Layering as many of these as you can together to give your regulators the comfort that these non-recorded ICs are going to be solid for future activities is key. We're also hoping that other water management districts, Northwest, South Florida Water Management District, Swanee River will advance to be able to use GIS shapefiles, so, and incorporate that into their permitting process to give DEP and other regulatory agencies comfort in applying NRICs. So with that,
Thank you, Joe.
you are welcome.
And by the way, just as a point, South Florida has done their first one.
With
Fine.
the South Florida Water Management District? Excellent.
So we're going to open it up for questions right now. We're going to open it up for questions right now. There's a microphone, if you can see it, in the middle. I'm going to, in order to give you guys time to get up, Wilbur, no fighting over the microphone. I'm going to ask one question as you guys start to queue up a little bit. And this is coming off of Ralph's earlier statement about PFAS, that should I look for it? If you look for it, you're going to find it. I think if we go around the room, everybody in this room could give an example of, oh, you should look for PFAS on this type of a site. But are you guys aware of anybody working on a protocol for when in the phase 1, phase 2 process you should definitively be looking for PFAS, PFOA, absent it was a fire training facility, but a general rule? I mean, we all know plastics plants, we all know fire training facilities, we all know if there was a fire that might have been put out with foam, but is there any other protocol that you guys are aware of?
I'll jump in real quick because we deal with a lot of sites in the context of due diligence. I don't know that there's so much a protocol as certain tells. My mother likes to call these Crime Stopper clues. Mm-hmm. Ralph identified a lot of the low-hanging fruit. We look at, we pay special attention to some of these sites that are operating in the shadows, but we think could be significant, of significant concern. One is C&D landfills that have concrete from other facilities that may have been subject to AFFF, like airport tarmacs being torn up and disposed of off-site. There are a lot of good technical studies that have been released. If anyone wants them, email me because I'm collecting all of them that speak to the prevalence of PFAS compounds in waste concrete, so that's number one. Number two is ag fields generally, because there's so much concern now about biosolids, PFAS and biosolids. Anytime we do due diligence on an ag site, we always ask the question, we struggle with it. And then the third situation is where sites have been filled with wastewater treatment plant sludges. We see more of that than you would think of, and we don't want that to be overlooked either.
What about purple pipe sites? Ralph, what about purple pipe sites?
I agree with Michael. There isn't an actual protocol, although the ASTM recently said you should look at PFAS. I'm not aware in purple pipe sites that that's come up, but I'll make a general statement, and people keep telling me that I'm becoming more risk adverse in my old age, and that might be true. But my answer to the question is always yes, you should look for it. If there's any category where PFAS might be in a waste stream, you should look for it, because it's better to know than not to know and find out later. And like I said, if winter isn't here yet, it's coming, and in 2 years, it will be here full on. Mm-hmm. And I'd rather know before then, so I can get out ahead of the regulators, frankly, with a solution.
Okay, thanks, guys. Mr. Mayorga. Is that microphone on, guys?
No, I already. Okay, thank
There
you.
we go.
I just would like to echo the last comment for the PFAS, because what I wanted to highlight, one of the true benefits of the DEP work with dry cleaners and others with the PFAS investigation, notwithstanding the reservations, is the effort, the priority to risk sector-driven assessment. And what I mean with that is to identify those off-site places where you have private wells, where those individuals were exposed to PFAS, not at the concentration you expect from the water treatment facility, but at much higher concentrations, where you can target those individuals and provide assistance and the necessary filtration. So that's something that DEP did. I represent Miami-Dade County, and that was an effort that was still ongoing. Notwithstanding the pending issue that you frame, it's important to identify those risk sectors that are exposed to concentrations not in the few hundreds, but in the thousands PPT.
Wilbur, do you think that militates towards a remedial path where money is concentrated overall in getting Florida out of the potable well system, the individual potable well system, and into a unified system?
Well, and as you may recall, the EDP was the genesis of the water trust funds in order to assist the private well community. So I think we need to do further efforts on that. So, but I just wanted to highlight your last statements and point out the priority that DEP and us are doing precisely to have a risk sector-driven assessment strategy with PFAS sites.
I think it's an excellent point, Wilbur, and I appreciate that. And I'm very, I mean, half of my PFAS clients are local governments. And again, that old joke that, you know, when you're in a tunnel and you see a light coming towards you, is that a train coming your way or the light at the end of the tunnel? I don't know. I think it's a train coming the way of the local governments because they have to deal with it.
Yeah.
And I've already seen municipal and county wastewater plants tell people that have historically had the same waste stream for decades that they're going to have to start looking for PFAS now because everybody sees it coming. So you're right.
Thank you. I appreciate it. And just a few observations, food for thought for the efforts with the non-recorded institutional control. And I have spoken about this before. So let me start with one of the assumptions made to support this strategy. The reliance on CHIP files and the reliance on the water management district, for example, to ensure that no inappropriate irrigation wells are permitted installed. We call, we verify. And all the answers that we were given by the South Florida Water Management District is that they did not look at any CHIP file to approve an irrigation well to ensure that it was not within a contaminated site. It might be a nice checkbox in a certain process, but it's just not real. Second, the assumption that municipalities in the state of Florida have their computer system when someone submits a building permit cross-linked to your nice registry or a GIS map file. I work with my county building department. That's not easy. And I can tell you that most municipalities do not have that. So it may sound that you're ensuring the protection because you say no building permit will be approved for dewatering activities linked to this register. That's not occurring. Unless the investment is there by specific municipalities or counties to have that cross-link, that is not occurring. So that may state the protection, but it's not achieving the protection. Number third, the notice. You're telling us that you provide a notice to the offsite property owners. That's only affected to the current property owner. Michael, the development cycle that we're dealing in Miami-Dade County, your example of transitions of property ownership even before redevelopment, just when you get comfort. So you don't have the notice to the next current property owner. And that's an emphasis that I have conveyed to all of you with this issue. For us, it's critical that there is an instrument that survives all these issues and is carried from property owner to property owner. So they know they're going to install an irrigation well and they may get a drip install it, but they know now that they shouldn't have it. And by the way, I'm not talking hypothetical. I'm dealing with property owners that install irrigation wells that I'm issuing letters. So there's not that level of protection. I have more because the irrigation scenario is actually concerning from different faith and transport issues, but I'll be respectful to my colleagues here, so I don't want to take all the time, but I just wanted to food for thought, be cautious with this process. There are weaknesses that are inherent to the reliance on some of these controls that are not necessarily what you assume they are. Thank you.
If I may address the third point, that's an argument that the DEP has been making for years in opposition to the use of these non-recorded institutional controls. And depending on who's in office, again, back to the politics, those arguments have either gone somewhere or not. I'm happy to hear that they seem to be more sympathetic to the concept now. But my answer to that is, and to your very important point, is as far as subsequent landowners, sure, having a restrictive covenant, a recorded restrictive covenant is one way, but there's other ways too. And if you're not doing as part of your due diligence a review of the local government laws, ordinances, restrictions that are put in place, you're not doing your due diligence. So future landowners can find out, because in my opinion, local government controls are just as effective, and they don't have a chilling effect on property transactions like the restrictive covenants do. So, I mean, that's the argument we make in response to that third point about how do you protect future owners.
Good morning, everybody. Steve Hilfiker, founder of Environmental Risk Management, also involved with Florida Groundwater Association and Florida Brownfield Association. Thank you, Ralph, Joe, Michael, and Howard. Great presentation. Quick question on the status of the Florida Attorney General claim against the major chemical companies, and after the status, is there any possible projection for any outcome from that may lead to a PFAS program?
Hey, happy to answer that for you. No one knows. I wish I had an answer for you. I could make one up. No one knew what was going to happen with the City of Stewart case, and a $14 or $15 billion settlement just occurred, right? And believe me, the manufacturers fought tooth and nail to the bitter end. And it was literally the Sunday night before the Monday morning trial was supposed to start that they caved in. And I think it's because they knew from all the previous testimony that had been received and from the judge's orders that they were going to lose. So you can't, like they say about the stock market, past performance is not a guarantee of future results, but I think the writing is on the wall. I think that there's going to be major liability determined either through a trial or through a settlement. And again, we're all waiting to see what the operative criteria is going to be that we're measuring against. But I think the manufacturers at this point recognize they're in trouble. That's why you're seeing bankruptcy start to occur.
So, Ralph, is this similar to, if you notice, Royal Dutch Shell has never lost a case on dieldrin because they've settled every claim?
That's right.
Do you think this
Yes.
starts walking us towards a lot
Yes.
more settlements?
Yeah, and if I may, somebody mentioned EDB. I actually represented all the manufacturers in that litigation many, many decades ago and worked on the rule that ended up with the delineated areas. I'm a huge fan of delineated areas. In fact, I was told by a friend at Northwest Florida that they would consider them now. So we're making progress. Mm-hmm. I think we need an EDB type fund, or if you want to go back even further, a Johns Manville asbestos fund, where there's a contribution from major manufacturers and from the government to create a fund and a claims process to go through that. And it's going to be a $1 trillion fund. It's not going to be a $1 billion fund or a multi-million-dollar fund like the EDB settlement was. So that's the only concept I can see that's going to work, really. Otherwise, there's going to be thousands of trials going on for decades.
Thank you. That'll be important for future planning, again, regarding PFAS, legislative policy, cleanup programs, things along those lines. Obviously, the key question is cost and time, and we'll be paying attention to those issues.
I'll give you another real-world example, and I won't mention which airport it is, but there's one airport in Florida that's just completed its evaluation. One airport, $250 million anticipated cost to remediate at 4 parts per trillion if that becomes the standard. Okay, so that gives you, and there's dozens of regulated airports, not to mention the smaller ones, not to mention all the other facilities. That's why I keep saying there's not enough in gold in Fort Knox if that's pressed upon us.
And quick question regarding House Bill 1475 and the January 1st, 2025 date for DEP to begin rulemaking regarding PFAS. If the EPA does not come up with the standard before then, is the DEP directive from the legislature, is the directive to start rulemaking January 1st of 2025 or to have it completed by January 1st.
They have to have it completed. They have to report back to the legislature, which is why I don't know how that's going to be possible. My guess is, from talking to some folks at the department, they're probably, maybe even this session, going to ask for an extension of that, because EPA won't be done by then. Even if EPA comes out with their final rule, I promise you there will be dozens, maybe hundreds of rule challenges. So we're still 2, 3, maybe longer years away from EPA having something that DEP can rely upon. That's the risk right now for DEP.
Great job with the NRICs. Michael, Joe, I believe the NRICs are a very, very vital solution to this complicated problem. Thank you very much.
Any more questions?
Yes, good morning. Hello?
Yes.
Can you hear me? Yes. Albert Rodriguez with Ambient Technologies. And I have kind of a crazy question looking for the future. We have done a lot of PFAS sampling, but we want to know if you see PFAS becoming kind of the petroleum restoration program, in the future. That there will be enough investment, enough growth in this whole process, which, it sadly kind of benefits us to be able to keep on moving on the PFAS cleanup projects. Can anybody give me any view of the future of what's going to happen?
Well, I can tell you that my friend Jorge and I joked that we should go into the PFAS testing and remediation business, if that answers your question. I think it's going to be here for a very long time. When we started testing 5 years ago, there was one lab in the country, a lab in California, that could test to the parts per trillion. Now, of course, there's a lot more that are getting certified under an ELAP for that. But I think if it's not here, it's coming, and it's coming quick, that light at the end of the tunnel. And I would certainly see investments in laboratory technology and remediation techniques, as many of you are into already, is definitely, again, I've never seen in 40 years a bigger environmental problem.
And if you go to the PFAS conference, and I suggest you guys all do, you'll notice there's no shortage of discussions on remedial technology. Largely focusing a lot on leachate and dealing with landfill leachate, but there's no shortage of discussions and presentations on remedial technology.
First time I did one of these 5 or 6 years ago, people were, well, what do we do? Pump and treat carbon filtration. That was it. Nobody had anything else to offer. Now there's lots and lots of really exciting,
interesting stuff.
But again, nothing's been blessed yet, if you will, but that's coming.
One other thing about cleanup target levels, EPA has also developed regional screening levels for, I think, 4 compounds. They're all down in the 4 parts per trillion range as well. And the DoD across the country is moving forward and using those RSLs and draft MCLs as target levels for their assessments. They're all in the process of just assessing it. They haven't really implemented any remedial measures, but they're using these lower numbers already.
Well, and I'm sorry, go ahead, Michael.
Just 2 quick points. With respect to those 4 other compounds that EPA is focusing on, they're looking at the additive effect of those compounds. They've established a hazard index of 1, so also a very, very low threshold. That's the first point. The other point I want to make is for tracking state-of-the-art in terms of PFAS remediation technology, I would encourage this group to track what the Department of Defense is doing. They are on the leading edge. They recently issued a new guidance for incineration of PFAS that's interesting and provides a good sense for where the private marketplace may be heading.
Michael's right. They were the first ones to receive the love letters from EPA and from the state. Of course, their response was, we have lots of bombs on our facility. Go away and leave us alone. And so after they responded thusly, and I'm only semi-joking, take a look at their response letters back to the state, for example. It was like, go away, we got this. They do have it, and they are now on the leading edge, as Michael said, and they are developing. They're out ahead of EPA with all their vast resources, because some of the most heavily contaminated sites are in fact DoD facilities, because they have all the bombs that they explode and fires they start, and guess how they put out the fires with PFAS foam,
Right.
okay?
And some of the most heavily impacted populations are
right.
military personnel.
Right, so yeah, that's a good suggestion.
One other thing, ITRC just came up with an updated guidance document for PFAS for practitioners that are.
Let me go, we're at 10. Any last questions? If not, thank you very much for your attention. Thank you guys for a great presentation.
Ralph?